Good afternoon, Your Honor. Edward Rivers on behalf of Christopher Willis. Christopher Willis.
You're requesting an adjournment.
That's correct, Your Honor. I'd like to address the bond conditions at the appropriate time.
All right. Probable cause conference will be adjourned March 27, 2025, 9 a.m. As to bond.
Regarding bond in this case, there are 2 counts of resisting that are currently charged. And one of the bond conditions, there was an individual that was present during the event that occurred. And one of those individuals, there was a no contact that was put in place, a no go to. The person in question is his girlfriend that he shares children in common. And then since he was arraigned, he's been having to reside at a different location and have his mother and her mother assist with exchanges of the children just to get the kids back and forth. But they do reside together. They tend to stay together. There was no charge of domestic violence, and certainly here the report can speak for itself and the prosecutor can have their opportunity to give a statement, but I'd like the no go to provisions lifted. I like the no contact lifted.
Response.
Your Honor, just for backstory, the facts of this case involved the defendant was attempting to rent a U-Haul. He was basically got into a argument with the person working at U-Haul over his ability to rent it. They contacted the police because of the way he was behaving.
We're barely 30 seconds in, and already the courtroom hits us with bond conditions, aka the invisible leash that decides whether you go home or sit in a cold cell. Christopher Willis finds himself in a legal chokehold, not because of a domestic violence charge, there isn't one, but because of how the court interprets what could have happened. The judge isn't just looking at charges, they're playing chess with behavior patterns. And if you think your girlfriend's just a witness, nope, she's now a legal landmine.
Police arrived on scene. As they were attempting to make contact with the defendant, he was arguing with someone, a female who may or may not have been his girlfriend. I'm not sure about that. She was basically trying to calm him down. And based on what the police reported, he shoved her away, and that's when the police were like, we're going to place you under arrest, and then he fought with the police officers. So that's the basis for why that bond condition is made in there. That individual is not a victim on this offense. There was no assault and battery or anything charged out of that conduct. That said,
But I mean, she would be a material witness.
She would be a witness, yes. And I think that based on those facts, while they certainly didn't lead to a separate charge, I would ask that that condition remain in effect at least for the time being.
If I just may add, Your Honor,
Go ahead.
I've been able to review the video. Everything was seen on body cam. That individual is here and present in the court today. Would be able to address the court if there's any concerns with contact.
I think what I'm going to do is I'm going to leave that condition in place. Maybe at this time. The Washtenaw address is the U-Haul place, is that right?
That's correct.
Because I have 2 places. And so the
prosecution paints a chaotic scene outside a U-Haul, arguing, shoving, and resisting arrest. But instead of a clear-cut domestic violence charge, they left it out. Why? Probably because the girlfriend wasn't willing to play the victim card. Still, the court treats the situation like a live grenade. Defense wants contact restrictions dropped, but the judge ain't buying it. Even body cam footage and live statements from the girlfriend can't save Willis. Bond restrictions. Stay locked.
Let's see what they did. I mean, and I understand what you're saying, that there haven't been charges regarding a domestic. However, and maybe that's because of what was presumed to be her status, but theoretically, I guess, if the allegations of the people are true, there could be, at which then these conditions would go into place.
Mm-hmm.
And so I'm going to sort of take the broadest sense of things. And so I'm going to deny your request to change bond. That may change once the examination comes around and you are before Judge Moore, or at some point you can take another look at that. But given what I'm hearing today, I think the bond condition is appropriate given the circumstances. And so bond will continue closed. That's denied. Thank you.
Brian, Stephanie, state your name.
Stephanie Sarine.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of use of a Schedule 1-2 controlled substance, and that plea, I guess, is being taken under 7411.
That's correct.
There's also, and upon her successful plea to that charge, count 1 would be dismissed. There's also the agreement between the parties of no upfront jail. However, this is not my case. I cannot buy Judge prior to that, so the parties should be aware of that.
Enter Stephanie Sin, a new defendant, new drama. She's pleading guilty to using a Schedule I or II controlled substance, which means drugs serious enough to make the courtroom sit up straight. It's a 7411 plea, basically a lifeline for first time. Drug users to dodge jail if they stay clean. But here's the twist. Her sentencing is someone else's problem, Judge Barr's. So this courtroom becomes a pit stop on her way to redemption or relapse.
And I explained that to my client, and she signed it out. The sentencing judge waived.
All right, very good. May I have her sworn?
State your name.
Stephanie Sarine.
All right, ma'am, it is this court's understanding you're going to plead guilty to the charge of use of a Schedule 1 or 2 controlled substance. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr
Yes,
in
Your
the
Honor.
1482 District Court.
Yes, Your Honor.
All right, understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of February 23rd, 2023 and March 16, 2023, at the location of 5301 East Huron River Drive, Superior Township, Washtenaw County, State of Michigan, did you have a Schedule 1 or Schedule 2 controlled substance in your possession?
Yes.
All right. Did you have any authority to have either one of those in your possession?
No, Your Honor.
All right. And had you used them?
Yes, Your Honor.
All right. Counsel?
I do want to clarify one thing.
Yes.
My client is not on probation or parole to any other court. She's actually technically
The judge goes full checklist mode. Probation? No. Coercion? No. Does she really believe she's guilty? Yes. It's almost robotic until we hear the timeline. Stephanie had that substance in her possession for weeks, not hours. And yet she still gets a shot at leniency. Why? Because sometimes the system bends, but only if you say all the magic words and promise not to screw it up. She's lucky, but it's clear This is her last free pass.
Technically on probation with, to Lara, correct?
All right. Have I complied with the court ruling? Would it be proper to accept?
The people are satisfied.
Yes, Your Honor.
All right.
I will get right there, right?
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
Before Judge Barr.
April 15, 2025, 10 a.m. before Judge Barr.
Okay. Your Honor, we're going to work on maybe moving that date and ask the court if it would permit a travel request from April 9 to April 15th. My client's parents, who are actually sitting in the car out in the lot, have family travel to Florida, and they want their daughter to join them.
I kept shaking my head no, and he kept talking. He just wasn't paying attention. That's 2. That and the staple, Simon. What are the dates of travel?
April 9 to April 15th.
And you'll be returning on the 15th?
Mhm.
All right.
Yes.
I'll allow that, only subject to one caveat. If for whatever reason the date does not get moved in 14A2 for sentencing, then you cannot go, or you must come back on the 14th. You have to be at sentencing. Okay?
Thank
Very
you.
good.
Your Honor.
All right. Thank you.
A gentleman from the earlier block was looking for a public defender. And I'm just
Oh, okay.
Find one.
He just needs to throw a stone. I'm sure he'll hit one. I shouldn't say that.
Sometimes it's harder than it.
Yeah, it is. All right. I called the Baker matter.
Thank you. Andrew Childers appearing on behalf of people.
Nicholas Stern on behalf of Mr. Baker, Your Honor, who appears before you via Zoom.
All right. Mr. Baker, can you state your name, please, sir?
Brandon Baker.
Thank you. All right. What are we doing today?
Now, it's my understanding that Mr. Baker will be entering a plea to
Cue the travel request segment. Yes, you heard that right. The defendant wants to go to Florida with her parents between now and sentencing. You'd think the court would laugh that off. But nope, the judge actually says yes, as long as she promises to be back if sentencing doesn't get pushed. It's surreal. 1 minute you're pleading guilty to drug charges, the next you're catching flights. Justice isn't blind. It's just got a flexible travel policy.
count 2 on the complaint. The count 1 of felonious assault would be dismissed. And I would just place on the record, I wouldn't necessarily call this a plea agreement. Based on my review of the facts of the case, I don't believe that this case was properly charged. That count 1 should not have been charged. And it's my understanding that Mr. Baker will enter a plea to the count 2, which is fail to report property damage accident.
Okay. Is that a correct statement, counsel?
That's correct, Your Honor.
All right. Very good. Okay. Mr. Baker, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please, sir.
Brandon Baker.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of failure to stop at the scene of a property damage accident involving an attended vehicle. That is a misdemeanor punishable by up to 90 days incarceration and a $100 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Understand, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes, Your Honor.
October 22nd, 2024, I-94 near Wired Road in Ypsilanti Township, Washington County, State of
Last act, Brandon Baker steps into the Zoom hot seat, charged with felonious assault. Nah, the court drops that and takes a plea for failure to stop at a property damage accident. Translation, he hit something, didn't stick around, and got caught later. The courtroom checks the boxes again. No parole, no threats, just a clean-cut guilty plea. But let's not ignore the real story here. A felony gets downgraded to a slap on the wrist, and just like that, another name moves through. The machine!